Good afternoon, dear colleagues. Thank you for coming. Thank you for those who watch us online. And the topic of our press conference is threat to activities of Anti-Corruption Prosecutor's Office and National Anti-Corruption Bureau of Ukraine. And our speakers are Kateryna Levchenko, Head of Selection Commission, and Viktor Shyshkin, Member of Selection Commission. So, speakers, please take the floor. Good afternoon, dear colleagues. Today is more than 2 months. The work continues in the sphere of selection of candidates for special anti-corruption prosecutor's office. And you know that there are many attention to this issue. There are many rumors and insinuations, but now we may say that competition is coming to its end, and the list of candidates is provided to the office of the General Prosecutor, and Kholodnitsky is appointed at his position, and the first deputy position is also occupied by Masih Grishuk, Vladimir Krivenko, and yesterday they appointed the head of division, and Andrei Dovgany, and the head of one of the departments of analytical and statistical department, Lyudmila Vigivska. And the commission will meet and recommend to special prosecutor's office other 3 candidatures, and next week we will end this procedure, and we will submit the list of candidates for all the main positions of Anti-Corruption Prosecutor's Office. So 2 levels will be created: the head of the Prosecutor's Office and his deputies, and then there will be the positions of inspectors and prosecutors. Commission worked objectively and under current legislation, and for us it was very important. And this work of the Commission, the work was independent, and it was supported by international organizations, and it was recognized by different organizations and independent experts. So we are close to conclusions of our work, but I want to say that mainly it's not correct to say like that, because now we have some court proceedings, because those candidates who applied, some of them filed the cases that they are not agree that they didn't agree that they didn't undergo this contest. So we analyzed these proceedings. We may say that this is the attempt to stop the work of Anti-Corruption Bureau of Ukraine, Special Prosecutor's Office, without which the Bureau cannot work. And they try to stop the movement that is provided by the state and society in the way of formation of bodies that should fight corruption. I won't remind you about the acuteness of this problem. Many people spoke about it, and the competence of the Commission is the submission of lists of candidates for positions. And we see it as an organized opposition of those people who oppose the processes. And some people, they don't like the situation, and these people, they try to stop those changes that were started in our country and that are introduced by the Anti-Corruption Prosecutor's Office. Of course, there are social lifts in the state, and those young and professional specialists that work in prosecutor's office, who worked at the grassroots level, they can reach top level. And now we consider candidates for the positions of the heads of the departments. We have such people from Dnipropetrovsk, Poltava, Donetsk, Lugansk, Sumy, and other cities of Ukraine. And we hope that the choice made by Commission will be supported by the heads of Special Anti-Corruption Prosecutor's Office. Meanwhile, I want to say that to some extent, some lawsuits that of these people, they are the result of an ambiguity and in the current legislation. We say about provision 3.1, in which it is said that specialists that work during 5 years before this law started till 15th of July 2015, that these persons cannot work in law enforcement bodies and prosecutor's office, that they cannot work in a special anti-corruption prosecutor's office. So those people who were appointed after March 2014, they were not able to take part in this competition. The Commission negatively assess this norm, but at the same time I would like to stress that we work in under current legislation, and we cannot provide our own opinions about this matter, in which way this decision is taken. And unfortunately, and this is supported by the protocols and video footage of this conference, part of these specialists who worked in these bodies under this provision 3.1, these specialists were not able to take part in these competitions, and now we have lawsuits and other proceedings of the Commission, and it's not the question to Commission, it's the question to lawmakers. And also the Council that on fighting corruption, I draw attention of the President and the members of National Council that we should introduce changes in the law on the Prosecutor's Office regarding Anti-Corruption Prosecutor's Office. And the introduction of such changes is planned for the beginning of 2016. And this is the part of agreement with the international organizations complaints, and I think that it's very important for us and for the civil society and for journalists. It's very important to monitor these changes. And the Commission is interested in these changes even now when we finished the first phase of our work. Why we are so interested? First of all, because it will make our legislation better. And this will make the work of the bodies, the work of which is regulated by the legislation. The work of the Commission doesn't end with the contest of this for the positions in the Anti-Corruption Prosecutor's Office, because under the law, if someone leaves his position in the Anti-Corruption Prosecutor's Office, so we should organize the contest for this position, and we will gather and we will meet, and the Commission will be formed, and this Commission will continue its work. So we have a lot to think about in terms of legislation, and I want to stress that all those actions that were made by the Commission, they were under current legislation of Ukraine, and any complaints about violations of the norms, I reject those claims that there were some violations. We reject these claims. Thank you for your attention. Thank you, Kateryna, and I invite Viktor to take the floor. And I remind about we have simultaneous translation here.
Thank you. Ms. Levchenko covered almost all of the problems, so I will answer your questions, but I also would like to elucidate several facts. We have 3 lawsuits with the courts. They are related to provisions 3.1 of the temporary provisions. Those persons who previously worked in anti-corruption authorities, they are disallowed to take part in our selection contest. And I am sure that our Commission reviewed the documents of the candidates in a very thorough manner. Since I'm a pensioner, so I can tell anything. You know that I was the first general prosecutor of Ukraine. Those days there were only 7,000 persons of staff, and now, and during Pshonka's being a general prosecutor, there were 17,000 prosecutors of staff. So 7,000 prosecutors could cope with the load of activities. So this structure, I had only 3 deputies, and my successors, they have from 9 to 11 deputy general prosecutors. So about the structure of General Prosecutor's Office, it is too inflated, too many people are working there. The chief department, then the chief unit within the chief department, and also the chief office within the chief unit What for do we need three levels, three layers within the prosecutor's office? I don't know. For example, in the commission, the chief department, if we take it, the title is for half page of text. You can look into the workbooks of such persons. Their positions are with so long titles that they take the whole page in their workbook, and the combating corruption should be in the title. So what is the chief unit within the chief department? The unit is the department or headquarters or office. What is this? And from the perspective of current legislation, in this case, not the chief department, but not the chief unit. This will be a chief office, and if the chief office title included the words anti-corruption, we disallowed the person from the selection, taking part in our selection procedure. So all the persons who were in the anti-corruption activities of previous regime, they were disallowed from taking part in our selection procedure. Also, their low professionalism. We also looked into this, their properties. That is why two of the three claims which are now ongoing in the courts, they were disallowed due to these reasons, that they were involved in anti-corruption offices at previously active authorities. We also had discussions whether anti-corruption could be included in such eligibility criteria. We looked into the definitions and we took the decision that combating corruption is the same as anti-corruption activities. This is the same as when we talk about preventive activities which prevent corruption. These words in the title also say against the person if he or she submits documents to work in new anti-corruption office. We would like also to say about the law that such persons can't work at any governmental positions due to the lustration. The prosecutor's office is a governmental office. That is why if the person is not allowed to be a civil servant, such person can't take part in the selection procedure for anti-corruption office staff because this person does not meet the eligibility criteria. So we can criticize the law, but the selection commission is not the body to assess the law and to give opinion that the law is not good. This is the task of other bodies to decide whether the law is constitutional or non-constitutional. So a person can file a suit with the court. So the court may then make findings that the person was fired in violation of the law. So we have such legislative problems. I would like to repeat that with the problems of criticizing the law and some other facts relating to narrowing the eligibility criteria, we were just in the same premises here in the Ukrainian Crisis Media Center. We used this platform and we voiced out that there are problems. We told about that in September this year. The amendments which were adopted in July to the law, they seemed to us controversial, and we submitted petitions to Mr. Groisman. But we are the body, the executive body. We are not lawmakers, so also we voiced out our complaints to the law, but we adhered to this law. Are there any questions, please? Mr. Shyshkin, Ms. Levchenko, please take the floor. We would like to ask you several questions. Fifth Canal, Yulia Bashko, you told that all those claims in courts, they can halt the operation of the anti-corruption prosecutor's office. Thank you for your question. You know that among the claims, there is such a requirement to ban the Commission, to prevent the Commission from taking certain activities. This means the meetings in which we can nominate the candidates to the administrative positions. This claim was heard on December 9th in the district court in Kiev, where a claimant, which was from the general prosecutor's office, he sought to stop the commission's activities because his submitted documents were disallowed, were not taken to the selection. This claim was rejected, and our activities of our commission were allowed to proceed. So the Commission operates according to the legislation, and denial from the selection, the denial of this candidate was in compliance with the law. The thing is that when some nominee tries to stop activities of our selection committee, he just wanted to destroy our selection commission and stop its operation. On our side, we are going to proceed and I would like to say that this person tried not only to defend his allegedly violated rights, but he also wanted to hold our activities. The other claims against us concern discrimination. The very broad definition of discrimination is used by the claimants. For example, the claimants say that discrimination in this case means that the eligibility criteria include not allowing the persons involved previously in anti-corruption activities. Talking about the discrimination, we should talk in the first turn about the parliament. They are excluded from the competition according to the eligibility criteria. And when persons go to courts and file lawsuits, initiate lawsuits, there is such a notion as the provision of the lawsuit. One of the three claimants whose case was tried on Wednesday, he wanted to halt our operations in order to ensure the proceedings, and the court denied his claim to stop the Commission's activities. To this extent, the judge rejected the claim seeking to halt the activities of the Selection Commission. Thank you, Mr. Shyshkin. Are there any more questions? Natalia Chekansova, Golos UA. There are three claims. Who are those persons? Who are those claimants? Are all of them subject to lustration? And what is the stage of the trials? There are two persons which are now working in the prosecutor's office. One of them is here now, and there are two persons who filed claims. Their main argument was that they worked in anti-corruption departments. That's why their documents were disallowed. One other was according to Article 36, Provision 7.2. It was the provision on lustration.
Thank you. And at 10:30 we have a meeting of our commission. Thank you for evaluating our work, and the work of the commission and prosecutor's office will be highlighted by the media. Thank you until the next time. And I remind that the next briefing is at 11:30.